program titled 18th Annual Workplace Class Action Litigation Report. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials along with the CLE attendance form will be distributed to the attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. At this time, I would like to turn it over to our first speaker for today's program, Carrie Friedrichs. Carrie, please go ahead.
Thank you. I am Carrie Friedrichs, and it's my privilege to begin by introducing my colleague, Ian Morrison. Ian co-chairs Seyfarth's ERISA and Employee Benefits Litigation Practice Group. With nearly 25 years of ERISA litigation experience, Ian has handled just about every type of ERISA case imaginable, and also has handled numerous benefits cases arising under state law. Ian litigates in courts around the country. The Legal 500 has recognized Ian as one of the nation's leading ERISA litigation practitioners, and clients seek out Ian to defend their most significant class action matters. Ian has defeated cases at the motion to dismiss stage, successfully opposed class certification, obtained summary judgment, and prevailed at trial in ERISA class cases. Ian is a regular speaker and writer on ERISA litigation issues, and he serves as co-chair of the Board of Senior Editors of Employee Benefits Law, which is the leading treatise on all things ERISA. And with that, I will turn it over to Ian.
Thanks, Carrie. It's a pleasure to be on the panel with my partner, Carrie Friedrichs, from our San Francisco office. And Carrie is the vice chair of our National Wage and Hour Practice Group. She draws on many years of experience focusing on wage and hour law almost exclusively, assisting clients with all aspects of wage and hour compliance and litigation, and developing and implementing a wide variety of pay structures. Carrie works with clients across all industries, focusing on healthcare, technology, and financial services, with a particularly strong background representing clients in the healthcare industry, given her particular understanding of the context in which hospitals operate. This helps her to develop practical, workable solutions to compliance matters. Jen?
Thanks, Ian. It's my pleasure to introduce Jerry Mattman. As many of you already know, Jerry is a partner in our Chicago and New York offices. He co-chairs our class action practice group. Once again this year, Jerry achieved a litany of remarkable accomplishments in the courthouse and still somehow managed to author yet another edition of the annual Workplace Class Action Litigation Report in his spare time. Jerry's 2021 was highlighted by a number of precedent-setting victories in substantial class actions across the country, ranging from outright dismissal to persuasive arguments on appeal and to the dismantling of massive class and collective actions. As a result, and for the 6th time in 8 years, Jerry was selected by Law 360 as an employment MVP, an award that recognizes the top 5 attorneys in the U.S. for each of their respective areas of law. Given the selective nature of the award, it's exceedingly rare for any one person to be selected multiple times. And Jerry has won the award more times than any lawyer in the country. Just this past week, Chambers recognized Jerry's work in its 2022 global ranking. It stated, "Mr. Mattman is absolutely phenomenal, as he is one of the top class action minds in the country." Jerry, over to you.
Thanks, Jen. It's an honor and a privilege to be with my 3 partners on this panel and be with you today. I am to introduce Jen Riley, a partner in our Chicago office. We've worked together for over 20 years, and Jen has handled all types and varieties of complex employment-related litigation, including class actions and collective actions throughout the United States. She's an innovative thinker and has been selected as one of the top 10 thought leaders in terms of class actions and thought leadership in writing about class actions. She also has a subspecialty in biometric workplace privacy violations and helping companies navigate through the thicket of those particular laws. So the four of us are your discussion leaders today. Next slide, please. And what we're going to do is focus on the agenda that is sketched out on this particular slide in 6 key areas. And we're going to use the 18th annual report as the focal point of these discussions. The report was published in the first week of January and thus far has been distributed to over 15,000 clients. The way we develop this is 365, 24/7. Every day of the year, we download all the class action rulings and settlements that occur throughout the United States and federal and state courts. We analyze those rulings and settlements, put them in a database. Since we've been doing this for 18 years, we now have a database of over 26,000 rulings, and we use this database to analyze trends, statistics, and key rulings that make up the workplace class action world that face employers throughout the United States. So our goal today is to synthesize the 1,607 rulings that made up this year's class action report and to provide our thoughts on what's hot and what are areas of concern as employers go into 2022. Next slide, please. The very first area we're going to focus on are settlement trends. And in a word or two, I think you could characterize what occurred this year as extraordinary, incredible, or phenomenal. Next slide, please. And the reason why is because settlements were up more than double from the year before and reached the highest levels ever in the 18 years that we have tracked these settlements. We derive these numbers and statistics from looking at the 10 largest settlements in 5 particular areas: employment discrimination class actions, wage and hour class and collective actions, ERISA class actions, government enforcement litigation, and a final category of statutory workplace class actions. And by that measure, those settlements reached the highest mark ever at $3.62 billion. And so you say to yourself, how does this impact me as an employer? And I think that what we have seen is it impacts employers in two ways. The first is the notion that success begets copycats, and skilled plaintiffs lawyers watch these numbers and are attracted to areas where lawsuits can be successfully flipped into money in terms of monetizing those particular class action filings. And so I expect, as we have seen in past years when the numbers go up, that in the following year there tend to be more lawsuits that are filed. I most definitely believe that's going to occur for employers in 2022. The second way in which these settlement numbers impact employers is in terms of the news cycle. And people either reading the news or watching it on their phone or in newspapers, and these settlements garner headlines, and it gets people thinking about their own particular circumstances and often leads them to visit plaintiffs' lawyers for an intake visit about their own pay, their own workplace experiences. And again, what we have seen from year to year is when the numbers go up, the number of lawsuits brought by private litigants go up. So we basically have a bit of a perfect storm here in terms of these statistics from year 2021 that are going to rebound and reverberate in the following year. Next slide, please. This particular slide, and these are graphics from Chapter 1 of the report, demonstrate the breakouts of the top 10 settlements per area. And what it shows when you peel back the onion skin on these numbers is that in the areas of wage and hour and ERISA, the settlements in 2021 were more than double what they were in 2020. And then when you look at statutory claims, the increase was tenfold. And so in that particular area, we saw an $852 million settlement involving a university in California. We saw a $575 million settlement involving a healthcare system in California. Simply stunning numbers by any measure in terms of the amount of money being garnered by the plaintiff's bar. When you look behind those numbers, you'll also see that in the areas of employment discrimination and government enforcement litigation, the numbers were actually down. And so it had a kind of a mixed bag here, but somewhat counterintuitive, because many people thought during COVID, cash was king, employers would hold on to that cash and would not depart with it. And exactly the opposite occurred in terms of more settlement money being paid in calendar year 2021 than in any year before. Ian, how about this trend in terms of looking at it from wage and hour class actions? Next slide, please.
Sure, Jerry. This graph really shows what Jerry's been talking about, which is that in 2021, we saw wage and hour settlements skyrocket from the prior 3 years. And this is showing that wage and hour settlements and wage and hour litigation remain a #1 threat for employers in the workplace class action arena. Over the last 5 years, the payouts have averaged over $500 million a year for a total of over $3 billion over the last 7 years. And what do we think is going to happen in the future? It's going to go up. We've seen plaintiffs' lawyers continue to refine their strategies and techniques, particularly trying to get around workplace arbitration and class action waivers in arbitration agreements. And attorneys are refining their strategies to get around those agreements in the wake of the Epic Systems decision, and we expect these numbers to simply go up as a result of those efforts. Jen?
Let's go to the next slide. So this slide details private statutory workplace class action settlements. This category includes settlements in 3 main areas. First, class claims for breach of employee benefits, other workplace injuries. Second, claims for violation of statutes such as the Fair Credit Reporting Act or WARN Act, as well as BIPA, the Biometric Information Privacy Act. And third, alleged violations for workplace antitrust laws. As Jerry mentioned earlier, the value of the top 10 settlements in this area in 2021 reached an astonishing $1.67 billion. That's at least 7 times the value of the top 10 settlements in 2020. So what's driving that number, or what drove that number in 2021? The claims that were largely responsible for that number arose in a couple of areas, primarily allegations of sexual misconduct or psychological trauma, as well as alleged violations of the biometric privacy laws. In terms of the top 2 sexual abuse cases, one of those included an $852 million settlement in the Central District of California against the University of Southern California, and one of them included a $71.5 million settlement in the Southern District of New York against Columbia University. Both of those cases involved allegations of sexual abuse at the hands of a staff gynecologist or obstetrician. In terms of the top BIPA cases, those included a $50 million settlement in Illinois Circuit Court against McDonald's for alleged violation of BIPA on the grounds that it collected fingerprint data without getting pre-approval or obtaining the consent of workers. It also included a $10 million settlement against Walmart for allegations that Walmart required workers to scan their handprints without first obtaining their consent. In this area, as Ian mentioned, especially given the prevalence of workplace class action waivers, we're continuing to see a migration of skilled plaintiff lawyers into these areas. And as a result, we don't expect that these numbers are going to go away anytime soon or really experience any kind of a decline in 2022. Let's go to the next slide. This slide details government-initiated enforcement litigation settlements. So for all types of government-initiated enforcement actions, the monetary value of the top 10 settlements in 2021 totaled $146.38 million. This does represent a sharp decline from 2020, but it represents a jump from what we saw in 2019. The majority of these settlements involved EEOC pattern and practice litigation, as well as enforcement actions and investigations by the DOL or Department of Labor, as well as the FTC. Unlike settlements in the other areas we've been talking about, such as workplace discrimination, wage and hour, ERISA, the trends in government-initiated enforcement litigation tend to follow the White House. So whether the White House is red versus blue tends to be a leading indicator in terms of the direction of enforcement litigation settlements. In 2018, during the second full year of the Trump administration, we saw the value of the top 10 settlements of government-initiated enforcement litigation plummet, as you can see from the graph. President Trump starved the agencies responsible for pursuing these types of actions, and as a result, we saw that number go down substantially. We expect to see the same type of reversal, but in the opposite direction during the Biden administration. Toward the end of 2021, President Biden got his people in place at the DOL, and in mid-2022, we expect that the Democrats will finally have a majority of commissioners at the EEOC. As a result, in 2022, we expect more litigation, more enforcement actions, and as a result, we expect to see these numbers go back up. Back to you, Carrie.
Great. So next, we'll discuss some of the trends that we're seeing in the class certification area. Next slide, please. The Workplace Class Action Report breaks down the various class certification and decertification decisions by circuit in each area of class action litigation, wage hour, employment discrimination, ERISA, and government enforcement litigation. So now we'll briefly cover some of the trends that we've seen in each of these areas. Next slide, please. So I'll start with trends in certification of FLSA claims. One trend that is very clear is that wage hour class actions remain a main focus of plaintiffs' counsel. While wage hour filings have actually decreased for the 6th year in a row, the number of FLSA lawsuits in each of the past 9 years exceeds the number in any year of the past several decades. This means that the federal courts currently are carrying a very heavy FLSA caseload, and this has led to more certifications of FLSA cases than in any other area of employment law. In 2021, we had more rulings on FLSA certification and decertification than in any of the past 5 years. As we can see from this chart, plaintiffs succeeded on conditional certification motions 81% of the time, which is very similar to the percentage in 2020. There was some good news for employers, as there was a slight increase in the rate at which decertification motions were granted at 53%, up from 50%. But on the whole, it looked like most of the positive news was for plaintiffs' attorneys in terms of certification matters. Of course, key factors impacting certification outcomes do include where the case is filed, the certification precedents in that circuit, and the view of the assigned judge on certification issues. We see a continuing trend in the 2nd, 9th, and 6th circuits of having far more wage hour cases than in any of the other circuits. Now I'll hand it back to Ian to discuss trends in employment discrimination and ERISA class actions.
Thanks, Carrie. So employment discrimination class actions were the highest or the most likely, and if we can go to the next slide, thanks, most likely to be certified at 72%. And we call this sort of the Walmart effect. And what seems to be going on is that the plaintiffs' bar, as Jerry noted at the beginning, have learned from their prior failures and attempts to get nationwide, giant class actions. Generally were not as successful as plaintiffs' lawyers had hoped, and so they've retooled, and now they bring smaller class actions, regional, statewide class actions, much more focused and much more likely to get certified. The FLSA class action certification numbers, again, are significant, very likely to get certified as a class action in the wage and hour space. And again, this is telling the story of learning by mistakes. The plaintiffs' bar have recovered from defeats in the arbitration sector and have generally retooled and are now bringing class actions on behalf of only those who didn't sign arbitration agreements, and trying to sort of pierce through class action waivers that employers have wisely put into their workplace arbitration programs. And in the ERISA space, the statistics were pretty much flat year to year, slightly more granted than denied, and that's likely a function of a couple of things that are going on in the ERISA space. One, fewer cases are getting to the class certification stage, because what tends to happen in these cases is that there's an initial motion to dismiss, and after that is denied, which has been the trend of late. The case settles pre-certification, and the certification happens as part of the settlement package. Or we've increasingly seen parties stipulating the certification in ERISA cases, given the way the courts have ruled. And so the number of contested decisions has really dropped in the ERISA space.
Let's go to the next slide. Thanks, Ian. So this graph shows the trend over the past 5 years for conditional certification and decertification in the wage and hour space. So the bad news for employers is on the left-hand side. In terms of conditional certification rulings, the trend over the past 5 years reflects a steady success rate for the plaintiff's bar. It ranged from a low of 73% in 2016 to a high of 84% in 2019. In this past year, in 2020, 2021, it hovered around 81%. So these positive results are more concentrated in plaintiff-friendly magnet jurisdictions, such as the ones Carrie talked about, Second Circuit and the Ninth Circuit. Now, whereas it's not all doom and gloom, a lot of employers have experienced some good successes in this area, but this is showing that courts tend to grant conditional certification of these cases in very high rates. The bright spot for employers is on the right side of the slide, which reflects the odds of prevailing at decertification. Employers succeeded on decertification this past year in 53% of the rulings issued. So for employers willing to brave discovery and get to the decertification stage, the news is positive in that over the past 5 years, employers have prevailed at the decertification stage more often than not, between 50 and 63% of the time. Let's go to the next slide. Jerry, back to you.
Thank you. The third area we look at and forecast and analyze trends would be government, administrative, and enforcement trends. This is an interesting area based on kind of the concept that Jen had mentioned before, that the White House or the occupant of the White House sets the tone, and whether it's a red or a blue administration has a lot to do with how intrusive government regulation and enforcement litigation can be, or the opposite. And I would say 2021 would be a transitional year. Next slide, please. What we saw was the beginning of changes with new agency personnel, President Biden getting his team and people into place, and the beginning of the retreat of Trump-era regulations that tended to be business-friendly, and the reversal of those regulations and putting into place regulatory memoranda and guidance that are more pro-labor, more pro-worker. And so during that kind of transition from where it was to where it is likely to be, 2021 did not see the full effectuation of what the Biden administration wishes to accomplish, and I think that is what we're going to see in 2022 and 2023. So inevitably, if you're running a company, if you're in charge of the HR arm of a company, you're going to see more government regulation, and you're going to see more government enforcement litigation. And so it kind of, in this area, begs the question of when a Department of Labor charge or an EEOC charge lands on your desk, what should you do with it? I think today that's a much different piece of mail than it might have been during the Trump administration, where more often than not, those charges didn't have legs and generate a tail of litigation that one had to deal with. Now, all of those charges, all of those complaints have the potential to grow into government enforcement lawsuits and are very serious things. I've always counseled clients that litigating with the United States government is a bit like trying to hold a hungry tiger by the tail. It's a very, very difficult situation where the government is not encumbered as private litigants by budgets or an unlimited budget, or litigating in the public interest where positions that are taken may seem very unreasonable and very aggressive. And that's what government administrative and enforcement litigation is all about. So I think the kind of good news, bad news would be the radar needs to go up for 2022. And I think when we have our 19th annual webinar and 19th annual report next January, we'll be able to conclude that the Biden administration put into place its pro-worker, pro-labor initiatives and began to execute on those to the benefit of those constituencies. Next slide, please, and back to Jen.
Thanks, Jerry. So our fourth trend deals with the continuing impact of COVID-19. It goes without saying that the COVID-19 pandemic has had a significant impact on the workplace in 2021. State and local governments continue to manage the COVID threat. Vaccines became widely available, and some employers attempted to move employees back to work or to hybrid arrangements. Those actions in turn led to government mandates, as well as to private employers updating, changing their policies, more temperature screenings, more protocols in place, and importantly, mandatory vaccination policies. Those steps then, of course, led to more controversy as groups such as unions, employee advocates, employer groups, individual employers brought challenges to those steps in the form of regulatory actions and challenges against the employer policies that were rolled out. Let's look here at this chart. So challenges to federal and state actions actually produced mixed results in 2021. Courts were less likely to curtail actions by state governments than they were by federal governments. For instance, the states of New York and Maine enacted vaccine mandates that were challenged on the ground that they violated constitutional rights because they failed to include things like religious exemptions. But the reviewing courts actually refused to grant injunctive relief, and the U.S. Supreme Court declined to get involved. As this graph shows, of the 41 motions for preliminary injunctive relief that were filed in 2021, only 15 or 41% of those motions were granted. Let's go to the next slide. Now, we saw a different result on the private employer front. So challenges to policies adopted by private employers. Those challenges faced low success rates in 2021, and defendants actually achieved high rates of success in terms of defeating claims as courts were reluctant to get involved and to interfere with actions of private employers in the workplace. In 2021, litigants challenged employer policies on various grounds, including that on grounds that they supposedly discriminated against individuals with disabilities, or they failed to allow for religious accommodations. And again, we saw mixed results, but largely employer favorable. In total, courts issued 65 opinions on motions to dismiss class claims related to COVID in 2021, and in 82% of those rulings, courts granted the motions either in whole or in part. Whole is the 57%, and in part is the 25%. In 2022, we expect that workplace class actions are going to continue to expand and morph in this area as we deal with yet another phase of the pandemic. Let's go to the next slide. Back to you, Carrie.
Great. The next topic we'll discuss is arbitration. Arbitration continues to have a significant impact in the class action world, particularly after the landmark decision in Epic Systems in 2018, reaffirming that the Federal Arbitration Act requires courts to enforce agreements to arbitrate according to the terms of those agreements, which can include class action waivers. As we can see from this slide, there has been a significant increase in motions to compel arbitration in federal courts over the past 5 years, from 63 in 2016 to 100 in 2021. Much of this increase is due to the fact that employers became much more likely to adopt arbitration agreements after EPIC systems. A current estimate is that 60 to 70% of private employers currently have arbitration agreements in place. As employers in California know, the EPIC decision did not slow down California plaintiffs' attorneys, who have increasingly focused on PAGA to bring representative claims. In a 2014 decision, Iskanian versus CLS Transportation, the California Supreme Court held that PAGA claims could not be subject to mandatory arbitration. So many plaintiffs simply pivoted to PAGA to bring representative actions where the employer otherwise required arbitration of employment claims. This all may change in the very near future as the US Supreme Court granted cert in the Viking River case. In this case, the Supreme Court will decide whether state courts are able to exclude certain claims like PAGA from federal arbitration requirements, or whether this would violate the FAA. This decision will also impact employers in other states that have also attempted to limit arbitration of employment claims. So we continue to see anti-arbitration legislation in Congress. While legislation overturning EPIC systems entirely is becoming less likely, there are other more narrow efforts underway to limit arbitration, including a bill to amend the FAA to prohibit mandatory arbitration of sexual harassment and sexual assault claims. And now I'll hand it back to Jerry to discuss some of the key class action rulings from 2021.
Thanks, Carrie. And before we get to that, I have the CLE code for all of our attendees. It is SS, as in Cypher Shaw, 4462. Again, that code is SS 4462. So this was the most challenging aspect of putting together our webinar, and that is, how in the world do you pick cases that you deem were the most important rulings to impact employers during 2021. The Workplace Class Action Report had 1,607 rulings that were analyzed in our 845-page book, and we culled through there and tried to think of, in each particular substantive area, what were rulings that were noteworthy and significant, and what rulings could a reader learn from in terms of what it meant for their company, or what it meant for the development of substantive law in the areas of employment discrimination, wage and hour, ERISA, and then what we call other cases, which is Chapter 9, which are all sorts of other class action related rulings that can impact any particular business. So what we did is we picked out 13 of those particular rulings, and as you'll see as we go through the following slides, there'll be a page number in brackets that is keyed to the page in the Workplace Class Action Report where the discussion and analysis of that particular case is found. And so what I'm holding up for those who can see on the screen is the book in hard copy form, and it's produced both as a hard copy book. A lot of people use it as a desk reference on their shelves. We also have it in ebook format, which is fully searchable depending on search terms that you might want to enter. And at the end of our session today, we'll give you the email addresses where you can order either the hard copy or the ebook. It's absolutely free, and it's a nice kind of bookmark that people keep on their computer to refer to and to as a guide to navigate through this thicket of workplace class action rulings. So what we're going to do is go to those particular areas. The first will be key employment discrimination certification rulings that Jen will handle on the next slide.
Thanks, Jerry. So here we have three key employment discrimination certification rulings. And what I like about putting these side by side is that they really show and they really illustrate that similar facts can lead to very different outcomes. So let's talk about them. So the first on the slide is Reese versus McDonald. This is a case out of the Western District of Michigan, decided right at year's end, December 29, 2021. In this case, 4 plaintiffs filed suit against entities that operated a McDonald's restaurant in Mason, Michigan. The plaintiffs claimed that a particular restaurant manager sexually harassed them in violation of Title VII. The court granted the plaintiff's motion for class certification in this case. So the defendants defended the claims, arguing that there really wasn't sufficient commonality among the circumstances faced by each of the class members. So the defendants argued that these individuals worked at different times, they worked different shifts, they experienced different degrees or types of harassment. Some worked with the alleged harasser for only 1 shift or only a few hours. Others worked with him more often. Some experienced direct physical contact, others didn't. The court rejected that argument. The court found that the class member circumstances were sufficiently similar. It distinguished this case from others on the grounds that in this case, the court found that the workers really didn't experience significantly different work environments at different times, or they didn't really have any variation in terms of the individuals contributing to the hostile environment. Instead, the court noted that the individuals worked in the same restaurant, in the same confined space, and they experienced harassment by the same individual. So now let's contrast that with the second case on the slide, which is Howard versus Cook County. This is a case that arose in the 7th Circuit. 10 women who worked at the Cook County Jail or the adjoining courthouse filed suit claiming that the sheriff's office failed to prevent male inmates from sexually harassing them. The district court in this case initially granted certification of a class of about 2,000 women. The 7th Circuit, however, reversed. The 7th Circuit held that the class could not stand because the women worked in materially different working environments. Their claims required separate, individualized analysis. So, similar to the McDonald's case we just talked about in terms of the allegations, but distinguishable perhaps on the grounds that McDonald's involved a single harasser rather than a lot of different harassers or alleged harassers, but still showing that very similar circumstances can yield different results depending on the jurisdiction. The third case on the slide, Riley versus FK United, no relation there. A group of job applicants filed a class action alleging that the defendant, who was an India-based company, gave preferential hiring treatment to foreign visa holders over U.S. citizens. So the allegation was that the employer would conduct a screening process for potential employees, and that screening process included a culture fit interview. So even though the plaintiffs pointed to this one aspect of the hiring process, the court denied the motion for class certification. It held in that case that the plaintiffs failed to demonstrate commonality because they failed to demonstrate that any glue really held together the reasons for the defendant's rejection of applicants. So some of the positions were never filled at all. Some of the candidates were rejected based on client evaluations. Some of the job positions had a requirement to be filled by a U.S. citizen or a green card holder, and the jobs themselves sufficiently varied. So this is a nice example for employers where, although the plaintiffs, as I mentioned, identified and pointed to a specific hiring practice, the court still refused to find commonality because the plaintiffs failed to show that that practice was really determinative in the hiring decision. Let's go to the next slide. Carrie, over to you.
Thank you. There were also many interesting wage and hour class action decisions in 2021. The first 2 cases that I'll discuss illustrate the importance of the standard the courts apply to determine whether an FLSA collective should be certified. And as with the employment discrimination area, these are some cases where the cases we're discussing will illustrate that the court that you're in really matters, and the standard that they apply really matters because cases with similar facts can lead to very different results based on those standards. The first of these cases is Curry v. P&G Auditors. In the Curry case, which was out of the Southern District of New York, the court granted conditional certification to a group of auditors who had been treated as independent contractors and who alleged that they were employees of one of the defendants, which was a bank, under the FLSA. In support of their conditional certification motion, the auditors argued that they were similarly situated with respect to the question of their classification as independent contractors of the bank. They submitted declarations setting forth some very basic evidence regarding their claims, including that they were all required to work through an LLC that the bank contracted with. They all submitted their hours through an online portal. They performed the same type of work, and they all worked over 40 hours a week without overtime. The court concluded that this showing was sufficient to merit conditional certification of the class, applying a very lenient standard requiring only a modest factual showing that the plaintiffs and others were victims of a common policy or plan that violated the law. The defendant, bank, argued that certification was not appropriate because it had presented evidence that plaintiffs were properly classified as independent contractors under the governing legal standard, but the court declined to even evaluate the merits, holding that merits questions are not part of the analysis at the conditional certification stage. So we can contrast the approach taken by the court in Curry with the Swales v. KLLM case, which is a case involving independent contractor truck drivers. In Swales, the Fifth Circuit rejected the type of very lenient standard that the court had applied in Curry, which is commonly applied in conditional certification of FLSA claims. This lenient standard was established in the Lusardi v. Xerox case in 1987, and it requires, again, only a modest factual showing that other employees are similarly situated to the plaintiff in order for a class to be conditionally certified. So in Swales, the Fifth Circuit rejected this standard and held that before conditionally certifying a class and allowing the notice to be sent, a trial court should first decide what facts and legal questions are material to determining whether a group of employees is similarly situated, then authorize preliminary discovery on those issues, and only after this, analyze all of the evidence and determine whether the employees actually are similarly situated. And this importantly includes merit-based evidence, which is not typically considered under the Lusardi standard. Applying this analysis, the Fifth Circuit vacated the district court certification order, which was very significant because it was really a departure from the approach that courts have taken in many other cases. Many think that the Swales decision may be the most significant FLSA ruling of 2021, and we certainly hope to see more courts adopting this approach. The second two cases I'll discuss are two decisions from the California Supreme Court in 2021 that already are having very significant impact on wage hour class and representative actions in California. While neither decision was actually on the issue of class certification, both of them addressed summary judgment rulings. They established standards that have a very significant impact on how courts evaluate meal and rest period claims for certification purposes. In FARA, the court held that meal and rest period penalties must be paid at the regular rate of pay and not the base rate of pay. This provides plaintiffs with another rate of pay claim that they can argue presents a uniform issue that can be resolved on a class-wide basis. In Donahue, the court held that where an employee's time records show non-compliant meal periods on their face, this raises a rebuttable presumption of a meal period violation, and it's the employer that is then required to prove as an affirmative defense that the employee was actually provided the opportunity to take a compliant meal period. In both Donahue and FARA, the court determined that the standards apply retroactively, so they already are having a direct impact on the approach that plaintiffs' attorneys are taking in existing litigation. And now I'll hand it back to Ian to discuss ERISA trends.
Thanks. challenged to find just 3 decisions to talk about in the ERISA space, but picked out 2 class certification denials since those are, I think, relatively fewer in number in the ERISA space and worth paying attention to. The first one was the Condrey decision, actually out of the Ninth Circuit, which surprisingly has been handing out some helpful ERISA decisions of late. Condrey was a multi-pronged lawsuit involving a number of different challenges to denials of benefits under health plans. And the district court on one of the claims had ruled at summary judgment that the insurer had violated ERISA's claim procedure requirements that the plan administrator write benefit denials, quote, in a manner calculated to be understood by the claimant. And the district court, as a result of that finding, then certified a class and said everybody else who'd received these allegedly defective benefit denial letters was, entitled to some form of relief. On appeal, the parties essentially, after getting some rulings from the district court, stipulated to dismiss the rest of the case so they could take the matter up on appeal to the Ninth Circuit. And the Ninth Circuit rejected a number of the district court's rulings, including that class certification ruling. But to get there, it first clarified that the law doesn't require exactly what the district court said. The district court had looked specifically at the denial letters and said the denial letters are cryptic. They just have codes in them, and they don't really explain to you how the insurer got to that conclusion. And the Ninth Circuit said, well, you have to look at the whole course of communications between the plan administrator and the participant. And if you look at that, in some cases you'll find sufficient information, some cases you won't. And of course, what you can see this turning into is a morass of individualized issues that makes it fundamentally uncertifiable, which is what the Ninth Circuit says. So when you're a defendant in an ERISA case, you want to find a way, like the defendants did here, to create that morass of uncertifiable individual issues, even if it means you have to sort of tweak the substantive law to get there. The Thorne case highlights another common failing of plaintiffs in ERISA cases and in class certification motions in ERISA cases, where they trip over standing issues and over issues involving a consistent approach across the class. And this case involved a fairly arcane issue of actuarial equivalency. The plaintiffs here were participants suing, saying that the factors that the plan administrator used to turn their normal retirement age benefit into an early retirement age benefit didn't result in actuarial equivalence. And to prove their case, they hired an expert who was perhaps too honest and said that there were 6 different models you could use to get to an appropriate actuarial equivalency. And of course, then on cross-examination by the defendants, was forced to concede that depending on which model you chose, some plaintiffs would like that model and some plaintiffs, class members, would not like the model. Because depending on the model, you might turn out better off or worse off. And he also conceded that there were several hundred members of the putative class who had actually suffered no harm at all under any of the 6 models. And when confronted with a class certification motion, the court found that there was no Rule 23A2 commonality because the different models showed that there really was no common question cutting across the class, that there were different views based on who you were and what factors might have applied to you. And the court also found that that defeated typicality. And then looking at Rule 23B1 and B2 certification, the court essentially relied on the same finding to say, look, there's no common thread here. There's no unified concern. And trying to certify the class under provisions that are concerned with having a uniform outcome is fundamentally inconsistent with what the plaintiffs were claiming in the case. And finally, the Smith case is not a class certification decision per se, but I would say it's required reading for anybody who is working on developing a workplace arbitration program that wants to cover employee benefit plans. And in Smith, the court was confronted with a lawsuit brought by ESOP participants who were challenging the initial startup of the ESOP plan and saying essentially the corporate insiders who were on the board of directors of the company had sold their stock to the plan at an inflated price that plummeted after the sale. And after that initial sale, the board had adopted an amendment to the ERISA plan to provide that any claim had to be arbitrated, and that in arbitration there would be no claims brought in a representative capacity or to confer benefit or relief to any other employee than the claimant. That provision was central to the Seventh Circuit's ruling. The plaintiffs here sued under provision of ERISA 1132A2, which authorizes, in a roundabout way, what the statute says is equitable or remedial relief for plan losses. And that can include, among other things, removal of a plan fiduciary. So the court here found that the arbitration provision was not enforceable because the plaintiffs sought, among other things, to have the fiduciaries of the plan removed. And the court went through an analysis applying the Supreme Court's arbitration precedents and said, first of all, there's no reason to say you can't arbitrate ERISA claims generally, but you're subject to, as the Supreme Court explained in the Italian Colors decision, a requirement that you not interfere with effective vindication of statutory rights. And the court then said, well, one of the statutory rights under ERISA is the right to bring claims seeking, among other things, removal of plan fiduciaries. And removing a plan fiduciary is inherently going to benefit or affect other participants in the plan than just the plaintiff. And so the court said you can't preclude that with your arbitration provision in this ERISA plan. And therefore nullified the plan in this particular case. The court stresses, of course, that it's a very narrow ruling here and that there were myriad other questions you'd need to discuss if you were going to find an arbitration provision enforceable, such as whether or not the participants actually agreed to it, and how the arbitration provision was adopted temporally compared to when the conduct at issue happened. But still, it's a decision that is worth a read if you're thinking about arbitration in the ERISA space. And on the next slide, I just briefly wanted to highlight three non-workplace specific Rule 23 rulings. As Jerry noted, we track these as well because they can include important lessons for anyone confronted with workplace class action. The first decision, the Gilbert decision, involved a claim by airline employees challenging uniform defects, essentially had to do with the bleeding of dyes from the uniforms. And the court there denied class certification in a ruling somewhat similar to the Thorne decision on the ERISA slide that I noted, because the court focused on the fact that the plaintiffs had not shown that they were actually really harmed here by this decision. Almost none of them had shown that they tried to return the allegedly defective uniforms or that there were any real problems in doing so. And the court said, that there's essentially no class issue here. In the Brooker versus New York City case, Jen had mentioned the COVID vaccine mandate litigation. This is an example of one of those many cases that was shut down relatively quickly by the court. Here, the plaintiffs, who were all people who'd received their first dose of the vaccine, sued challenging the mandate requiring them to get the rest of the sequence. And the court very quickly shut this case down, finding that these plaintiffs couldn't establish grounds to get injunctive relief because they couldn't show irreparable harm. Really points to first principles of litigation when you're confronted with a claim seeking equitable relief. And then finally, the Facebook case was a massive class action that essentially covered, I believe, everybody in Illinois who uses Facebook, which is probably 98% of the people in Illinois. And the court here was confronted with settlement approval. And interestingly, the court initially received a motion to approve a settlement of $550 million, but rejected it, essentially saying it was not enough money. So cautionary tale number one from this case is be careful that you may have pushback from the court that doesn't like your settlement. And then secondly, you'll note nearly a $100 million class settlement or class attorney's fee award here, which is really a stunning award for a case of this type. And Carrie?
Great. So what do the developments of 2021 mean for employers in 2022? As Jerry mentioned earlier, success begets copycats. The ease of bringing copycat litigation and proliferation of social media mean more class actions. Plaintiffs' attorneys are watching each other's cases. They're seeing where each other are having success. And we often see copycat litigation as new theories or approaches to cases are identified. Plaintiffs' attorneys also continue to use social media as a tool to recruit plaintiffs, and we expect to see plaintiffs' attorneys use social media in more creative ways. We expect that wage and hour cases will remain a large component of the workplace class action filings that we'll be seeing in 2022. The rapid change of the workplace in response to the pandemic has provided plaintiffs' attorneys with new theories on which to base their pay-related claims. And claims specific to COVID-19 issues will continue. Examples will likely include off-the-clock work claims regarding COVID screening procedures and vaccination and testing related claims. And again, with the new administration, we expect to see increased government enforcement litigation in 2022. Arbitration defenses will remain important and may even expand if we have a favorable decision from the Supreme Court in the Viking River case. But as we discussed earlier, efforts to limit arbitration continue, and this likely will remain a focus in 2022. And I'll hand it back to Jen to provide some thoughts on approaches to managing these risks.
Thanks, Carrie. Let's go to the next slide. Thank you. So what can employers do? Well, most of the class actions we've been talking about today could have been prevented. Things that an employer can do to prevent these type of cases include adopting a robust compliance mechanism. Solid HR fundamentals are crucial. Put in place early warning systems, such as reporting mechanisms, investigation processes, and remediation. Every claim is important. Every claim has the potential to expand. Every charge has the potential to become a pattern or practice allegation. Every complaint has the potential to mushroom into a class action. A solid arbitration program, as we've talked about a few different times today, remains one of the best defenses. Solid arbitration program with a class, collective, representative proceeding type waiver is one of the best devices for mitigating risk as well as for fracturing class claims. Ian, do you want to add to that?
Well, and I would highlight on the ERISA front, compliance is critical. As Jen noted, it's true for the HR area generally and also for employee benefit plans. And to really take heed of the note that every claim has the potential to expand. I think we've seen that as a thread throughout this. A single employment practice or a single benefit plan action blossoms into a massive class action. And the best defense is to head these off early in the process.
Next slide, please. So here would be the links where you could order the books. Here is a slide of last year's book. And we have all these books in storage, so anyone who would want the ebook can go back decades or more to get copies. They're free. And we would love for anyone who is interested to be able to go onto the site. We have a special standing site called workplaceclassactionreport.com where anyone can download that report. We have about a minute remaining, and we have a couple of questions from our audience. The first is from one of our guests from London, England, that asked, do we have also in the report have data on single plaintiff case trends? And actually we do. And if one goes to page 25 of the 18th Annual Workplace Class Action Report, we have a table and a graph with respect to all the filings of employment discrimination, wage and hour, ERISA cases from January 1 through December 31 of 2021. And what, in essence, it shows is filings were down across the board about 10%. and kind of our analysis of why those numbers were down, probably twofold. The first reason just being COVID and the fact that businesses, the government, courthouses kind of shut down or remote for a large portion of 2021. But the other reason would be workplace arbitration programs. I think our sense intuitively is about 60 to 70% of companies now have instituted workplace class action reports, have them in place, and it's cutting down on the amount of lawsuits. So we thank all of our participants in today's webinar and look forward to speaking with you next year about the developments in 2022. So have a great day. Thank you.